Azad, introducing you real quick. We've
Sure.
sort of known each other for a long time. We've been in the same ecosystem for a while now, but we've really started working hand in hand in the last maybe 3-4 months. And it's been an absolute honor to see you work and see your capabilities. Pretty astounding. And Straddling obviously is a extremely well-known brand in Southern California. Do you want to take a few minutes and just give us a little bit of your background?
Yeah, sure. I'm a shareholder here at Straddling. Straddling's as I call it, it's an entrepreneur's law firm. We work very closely with entrepreneurs. We take we consider ourselves as partners with the entrepreneurs, helping them through various stages of their ventures, starting early on when they're trying to incorporate the companies, issuing equity to the founders, through hiring team members, raising capital, trying to commercialize their products, doing distribution agreements, commercial agreements, and then eventually, having an exit. So Straddling is a one-stop shop. We are a corporate firm. We can address most of the needs of our clients, their business needs of our clients from a legal perspective. So like I said, we consider ourselves as a partner with our clients. And I'm a shareholder in the corporate and technology transactions group. I work very closely with emerging growth companies, and a lot of my clients are, at any stage, my clients would be folks that just walk in with an idea of wanting to incorporate a company, to folks that have, are trying to raise capital, be it friends and family, seed capitals, Series A, B, and clients that are looking for an exit, be it a M&A or public offering. So, like I said, we have a very good team here at Straddling, and we can bring in resources as needed to address our clients' needs.
Fantastic. And this is actually a perfect introduction to what we're doing here with our legal series.
Mm-hmm.
So this is going to be a 6-part series that we're going to record. We'll have one webinar every month. Today's webinar is the first in that series. And today we're going to focus on early stage companies and sort of legal issues for founders 101 kind of thing, right? So today we'll touch on, forming an entity, all of the major questions that go around it, touch on some terminology, touch on documentation, and how you guys actually capture everything that is important right as the company is getting started. Mm-hmm. Next event that we're going to have here will focus on the basics of funding. So when you're fundraising, what are the sort of issues that you come up with, and what do investors look for in a company, et cetera, et cetera. So that'll be the next step in the journey. And then as we go through, we'll sort of graduate to more and more advanced issues concerning the legal challenges for a founder. Again, this is great because this sort of walks the founder through step by step through all of the challenges that they might face in that journey. So having said all of that, let's get into today's event. We're going to focus on early stage founders. I think the first question that most founders have is, when is the right time to incorporate? Should I incorporate sooner rather than later? Should I wait, 6 months before I have a product when I'm signing on customers? What are those sort of the pros and cons? How should we think about this?
Well, and that's a question a lot of entrepreneurs ask. Like I said, for an entrepreneur, most entrepreneurs start with their, where they're bootstrapping their venture. They haven't raised money, capital from an outside source. So the capital is, whatever capital they have, they want to use that to build a team, to build a product. And so one of the questions that they tend to ask is, hey, when should I incorporate? When should I spend the limited capital I have to form a company, to hire a lawyer for doing that, and incur legal fees towards that? And my answer to that is that, why do you incorporate? Well, there are a few reasons why you want to incorporate. One is, the incorporation brings you a limitation of liability. Your personal assets are no longer at risk. So it brings you that the insurance sort of. The second is there are tax reasons for that, right? I mean, you want to, if you wait too long, there's already value in the company or in the product that you've generated. It becomes difficult then to bring on, co-founders, or there are tax consequences that you have to think about to bring on co-founders and other team members if you've waited too long to incorporate and issue equity. The third is very, very important. You want the intellectual property that you're creating, and we are talking of tech startups here. So one of the main assets for a tech startup is the intellectual property, the product that they're trying to create. It's very important, and I can't stress enough that it's for investors, and this happens right through the various phases of the company. The investors want to make sure that the intellectual property belongs to the company. It rests with the company. So if you have not, if you started working with a team, you've hired one or two contractors that you're working with, and those guys did not sign any documents because they were friends, and then now they're either you can find them or they're not willing to sign a document later on, then intellectual property becomes an issue. Ownership of IP becomes an issue. And so it's important that you think about that. And if you have a company, that's what gets you the investment. That gets you the legitimacy. When you're talking to an investor, be it friends and family investor, maybe if you're raising money from your dad, then probably it doesn't matter as much. But if you're talking to your friends, if you're talking to angel investors, they want to see a company, right? I mean, that's what they're investing in. And so you have to think about these things. And my suggestion always is that when you start, if you're working on your own, if you're trying to, working in your garage and you're writing your own code, that's fine. You can do that. There is no liability, right? I mean, you are by yourself. But once you start hiring people, be it you have a co-founder with you, or even if not a co-founder, if you've just hired someone to help you with writing the code, I think you should think about informing the company at that point in time, because like I said, the cost is less. It's not that expensive, but it brings you the protection that you're no longer putting your personal assets on the line.
Absolutely. So I think that's such a great way to think about it. So I guess the long and short of it is that register as early as you can. And if you're bootstrapping, the finances might be a little bit of a challenge, but it's still worth the money to get through that up front.
Right. Yeah, absolutely. Yeah. And, law firms are, especially the law firms that work with emerging growth companies, they understand the challenges. They understand that,
right.
that the capital, that entrepreneurs are short of capital. So there are ways and means that law firms work with the entrepreneurs. So yeah, I would think that you should think about incorporating early enough. And you should, again, you should be working with a law firm, with an attorney who works with startups, who understands this ecosystem, who understands the landscape, who understands what the investors are going to look for. It's important to have a legal counsel who can guide you through the process. A lot of the times people would end up going to online services to incorporate the companies, and those guys, they are not thinking through they're not thinking through what the entrepreneur is trying to achieve. They will give you a very low cost option, but when you go to an attorney, you will end up having to redo a lot of the stuff that you get. So my advice always is incorporate sooner than later, and try to work with an attorney who has who works with startups, so that you get the right documents and you're setting it up the right way.
Absolutely. And this is such a great point. Working with the right people is sort of a key thing that a lot of startups struggle with. But before we get into that, I just want to mention one thing to the audience. If you guys have any questions, please put them in, click on the Q&A button on the bottom of the screen and type them in. We'll try to answer as many questions as possible during the presentation. And if we don't, then we'll have at least 20-30 minutes, as I has promised us that time, to go through all the Q&A. So we'll definitely get to your question. Yeah, so let's continue this conversation about hiring the right person. Because the first question I have, and someone actually just asked this, is that what's the difference between LLC, S Corp, C Corp, all of these entities that exist? And obviously hiring the right attorney will get, they'll be able to help you select the right entity for you. But what's your take on all of these entities, and what's the pros and cons of using each one?
Yeah, so there are different forms of entities, right? I mean, there's a LLC, limited liability company. There are corporations. So those are two different forms of entities, right? And when you're starting a business, you have the choice whether you want to set it up as a LLC or you want to set it up as a corporation. Within a corporation, then you have choice, whether you want to be a C corporation or an S corporation. And like as to your point, well, your attorney, the person that you're working with, and this is my approach. If an entrepreneur comes to me and puts this question to me, hey, what should the entity be? Should it be a LLC or a C corp? Then there are a few things that the attorney needs to know. What is it that you're trying to achieve, right? I mean, are you going to bootstrap this on your own, or are you going to be raising capital? And if you're going to be raising capital, then are you going to be raising capital from friends and family or those kind of resources, or are you going to go out to institutional investors, sophisticated investors? And what is the time frame? If you're going to bootstrap it, then how long are you going to be? Are you kind of can you take it through all the stages of growth, or do you think that at some point in time you will try to raise capital and you will reach out to outside investors? So those are things that you want I always ask, and based on the answers that I get, I always suggest one way or the other. Now, the difference between the various entities is as follows. Now, if limited liability company is a pass-through entity. It's an LLC. Any entity that ends with the LLC at the end is a limited liability company. It's a pass-through entity. What that means is that there's no taxation at the company level. The profits and losses are passed through to the members. Now, the members of the LLC are the owners of the LLC. Just like you may have come up, shareholders or stockholders are the owners of a corporation. Likewise, members are the owners of a LLC. Like I said, it's a pass-through entity. No profit, no taxes at the company level. It's a very flexible. LLCs are a flexible structure. The one of the advantages of using a LLC is that it's very flexible. You can have a board of managers, but you don't need to have a board of managers. You can have officers, but you don't need to have officers. Unlike a corporation, where if you set up a corporation, you need to have board of directors, and you need to have certain officers. So there is a more formality to the corporation structure than an LLC. Now the question is, it gets you the same limited liability that the corporation has. It brings you the flexible structure. It brings you that pass-through benefits that sometimes people will say, hey, you know what, I'm starting this company. I have other sources of income. The losses that this venture is going to make for the initial years, can I use those to write off income from the other sources? Yes, so long as you're complying with, you should be talking to your accountant, and so long as you can do it, if your accountant advises you that you meet the requirements under the tax code, then yes, you can, and that's an advantage. But there are then we come to the question of with a startup. The question always is, how are you going to raise capital? What's your strategy? Are you going to
Right.
bootstrap this, or are you going to do you plan to raise capital? And so what you have to keep in mind is that the LLC structure is not favored by investors, especially in the tech space. Tech startup investors don't favor LLCs for the simple reason that what works for an entrepreneur from a pass-through perspective doesn't work for an investor. Now, think of it this way. If you are a fund and you are investing in, 10 companies, right? And if those 10 companies are LLCs, then those LLCs have a pass-through structure. At the end of the day, end of the year, they will issue you a K1, and you, as a fund, then you yourself are a pass-through structure. You have to take that K1 and then give it to your investors. Right. So it becomes an accounting nightmare for investors. So that's one reason that when the VCs don't like it, and a lot of the times, the investors in the VC funds will tell them that no, you cannot invest in a pass-through structure.
Right. And you touched on this very briefly, but talking to your accountant is also important, because we kept using the word pass-through, but pass-through has a couple of different implications, and one of the implications is the tax implication, right? Mm-hmm. So LLC versus an S corp obviously has tax consequences that are different, and yep. Or C corp, I should say, and you should certainly talk to your accountant before you make that decision.
Correct.
Yeah. So very important there.
Absolutely, and you need sophisticated accountants to have LLCs. Yep. Because just think of it this way: that at the end of the year, it is for the LLC to issue K1s to their owners.
Right.
To the members. They have to be issued on time. They have to be done properly, because those K1s are then used by folks to file their returns.
Yep.
So you need to have a sophisticated accountant, and it is expensive. The process is a little more expensive than having a C corp. Right. Then what we also see is, and this comes up, this comes up a lot in my experience, is that a lot of the people understand stock. They understand shares. They understand stock options. They understand restricted stock. Now these are the terms that are very commonly used in corporations. Right. In an LLC framework, you are using different terms. You're talking in terms of units, you're talking in terms of membership interest, you're talking in terms of profits interest, and a lot of the people are not familiar with those terms. Right. I may have worked with the startup in my past life, and I got stock options, and I vaguely understand what that means, but the startup was successful, and I ended up making money, so I like stock options. But if I come and start working with an LLC, and the entrepreneur puts a profits interest unit in front of me, and it has a lot of legal jargon, right. And then all of a sudden it just throws me off. Not that I understood the legal jargon options, but when right. I'm used to a stock option environment, I'm not used to a PIU environment. Right. So the paperwork and the terminology is very different, and that's something sometimes that you have to keep in mind.
Absolutely. Fantastic. So obviously now that, you decide you want either LLC or C Corp or S Corp, mm-hmm. The next question is, where should it be registered? Should it be in Delaware? If you're in California, then should it be in California? There are a couple of other states that always come up, Nevada, Wyoming. What's your take on, the state by state registration?
Yeah, I mean, see, my advice always is to go Delaware. Okay. If you are a tech startup, again, all these questions that W were asking, and these are very pertinent questions for a startup. Mm-hmm. These are questions that come up in my discussion all the time. If someone has not already formed an entity, and the person walks into my office with an idea and he wants to start a company, then these are questions that I ask. Yeah, these are the questions that the entrepreneur asks me, and the discussion then kind of revolves around the same things that I said earlier. Hey, what's your strategy? What's your fund capital strategy? A fundraising strategy. What is it that you want to achieve? Is this going to be your are you thinking of this as a lifestyle business, that you're going to run this, it's going to be a cash flow business and you run it forever and not think of selling it? Or are you thinking of this as a conventional tech startup, wherein you'll start now, you'll have 5 or 6 or 7 years of growth, and then you'll get acquired, right? And you'll generate wealth over the time, and so those are things that you ask the entrepreneur. And most of the times, I would say that 9 out of 10 times the answers are pretty much, oh, I would be raising capital. Yes, I will go out and raise capital from angel investors. Oh yeah, I may have a friends and family around, but that I don't think is going to last me long. So within 6 months to a year, I'll be out there trying to raise capital. And then yes, it's if you're raising capital, then you obviously understand that you're already thinking of an exit strategy, right? Because that's what the investors will want to know. So then we talk about let's go the corporation route, right? The choice there is C corporation, S corporation, like you alluded to. Yep. My recommendation always is that if you've decided you want to be a corporation, if you want to raise capital from investors, if you then you should go Delaware. Delaware C corporation is the entity that the investors most prefer. So it's like walking into a pitch and saying, hey, I am a Delaware C corp. It's kind of like checking the boxes, and you've one hurdle is already crossed. Right. If you walk into an investor pitch and you tell them that, hey, I'm a Nevada corporation, or I'm a California corporation, or I'm a LLC, be rest assured that not if they like the company, then they will invest. But before they put the money in, they will want you to convert into a Delaware corporation. Right. So anything that you've done until that time, whether you were LLC or you were a Nevada, California LLC or a California corporation, they would want you to convert into a Delaware corporation, and that has to happen before they invest. Now, sometimes the structures are the structures. The entrepreneurs have not done much with the company. By the time they're talking to investors, they haven't issued equity to too many people, so it's easier to convert. Right. If you have not complicated your cap table, the cap table is pretty straightforward, then it's that much more easier to just convert into a Delaware corporation. But sometimes what happens is that you've hired a team, you've issued membership interests to the team, you've issued profits interest units to the team, then it becomes complicated, and then the exercise also becomes expensive. So you have to think about that. You have to do that cost benefit analysis, that okay, being Delaware from the get-go, or being in California or any other state from the get-go and then converting to Delaware, how much am I trying to save? Yes, if you're in Delaware corporation, what you have to keep in mind is that the cons of that is, we've talked about the pros, but the downside of that is that if you are a tech entrepreneur based in California, you have a Delaware corporation, you have to qualify, or if you're doing business in California, meaning you're hiring people in California, then you have to qualify as a foreign company in California. So what that does is that you have to then pay franchise tax in Delaware and pay franchise tax in California. So that's sometimes entrepreneurs think, hey, why should I be paying tax in 2 places? Well, that's the cost of doing business in Delaware. I mean, you could save that cost of not paying franchise tax in Delaware for initial year or 2, and then when you convert, you will have to, you'll have legal expenses, and that I think the amount that you save will be less than what you end up spending to just convert.
Right. So I think one of the other key things about Delaware, it's also when you're exiting your company, it makes it a little bit easier. Can you talk a little bit about that?
Yeah. So the question is that why is Delaware so favored by the investors, right? I mean, most VCs are based up in the Bay Area, in the Silicon Valley. Why would they prefer why would they want California? So you have a California corporation with the investors being in California, but wanting the company to become a Delaware corporation.
Right.
So the reason is the multiple reasons for that. First and foremost, Delaware corporate law is the most advanced.
Okay.
They have a very well-developed body of law, corporate law. They have, they have a specialized court system that only deals with corporate law. So as a result of that, the corporate law has, the body of law has advanced in Delaware. Secondly, that there is a lot more predictability in the Delaware law, and that stems from the fact that, there's a court system, that the judgments that come out of that court system are consistent, and that they've been able to advance corporate law and in other states, and hence it's more predictable. It's more predictable from the investor's perspective. It's more predictable from the directors and officers' perspective, right? Then there's always the thing of, there are practical side to it, filings in Delaware. And this comes up a lot, not many times, filing documents in Delaware, it's much easier and much efficient and less expensive.
Okay.
Whereas in other states, it's the other way around. One example I always give is that if you file a document in California, if you file your articles of incorporation in California, of course, now we are in a different, very difficult environment. But even before COVID, California would have taken anywhere from 7 to 10 business days to get your articles of incorporation back.
Right.
You can expedite it, but you then have to pay extra fees for that.
Additional fee for it, yeah.
Yeah, additional fee, and used to be $350. I think it's still the same, but in Delaware, you file a document today, you will get it back in 2 to 3 business days. If you want to expedite it, you can. I think it's $100, and you can get it back the next day.
Wow. Okay.
Yeah. So it's that practical side of things as well. And then the Delaware, they are not going to nitpick on your documents. We see that California sometimes raises objections. Hey, you missed out. There's something. Your numbering is off, and
right.
Your filing gets rejected, and then you have to rush to make sure you get it filed back on the same day, because otherwise the money that you've paid to them that gets.
Okay.
Yeah.
So that Delaware, it sounds like, is the way to go. Now let's change sort of focus a little bit, and instead of looking at it more from a sort of legal and filing documents to sort of the actual functionality of a business. And one of the things that I always come across is, should I file as myself and then bring in a partner, or should we file as co-founders and have 2 people? That's always an interesting question when you're talking about bringing in additional people at the formation stage. What's your take on, should we have co-founders, or should it always start out as a solo company?
Well, no, there's no right or wrong answer to that. Whether you should have a co-founder, there's no requirement. If from a legal perspective, if you want to form a company, if you want to incorporate, if you want to form a corporation or form an LLC, there's no legal requirement that you should have a co-founder, right? I mean, you could, I could come up with an idea and I incorporate the company. I'm the sole founder. I'll be the sole director. I'll be the sole shareholder. I'll be the sole officer of the company. That's fine. Eventually I may find someone who's going to work with me, who has a complementary skill sets, helps with the company, and he may join as a co-founder. But to start a company, you don't need a co-founder.
Okay, right. Got it.
Yeah.
So
go ahead.
So no, I look at it from more of a risk return perspective. So filing documents is one thing, but when you're starting a company, if you have a co-founder, you're generally sort of sharing the risk as well as the return. So what's your perspective on that?
Yeah, you see, my perspective, and this is not so much a legal question. This is more of a business question. But my perspective here is as follows: that can one person do everything? there are, of course, there are, there are geniuses who can do that. But the thing is that you maybe you may have an idea which is technology based, right? And you can build the technology yourself. So you built the technology, but you may need someone who brings the business perspective
Right.
to the team, right? So now the question is, when should I start looking for someone? Should I start looking for someone right in the beginning? It's something that something that it's an individual question. I mean, one could say that, yeah, I have a great idea, but it'll be good to have some business perspective so that as I'm working on my idea, as I am developing my product, I'm getting some business inputs, some commercial inputs. And, if I get the right person, then why not? Right?
Yeah.
Or
Yeah.
one could say that, what, hey, I know I'm coming up with a medical device, right? I know what it's going to do. I need to build it, okay, then can you do everything by yourself? Or do you need other people, who can bring in technical perspective a different technical perspective to the whole idea.
Right.
So it just it depends on how you think about it. From an investor's perspective, that's another thing that you have to think about. What do the investors like to see? My general feeling is that the investors like to see a team.
Right.
They want to see a team. They if nothing else, it just gives them, it gives them the comfort that there are, more than just one person that they'll be.
Yeah, absolutely. And yeah, obviously, like you said, one person can't do it all, right? Even in technology, it could be hardware, it could be software, It could be marketing, sales.
Absolutely.
There are a lot of business moving pieces of the business that you sort of have to keep in mind. So now, if you are working with a team, then the obvious next question is that how do you start to define the roles from a legal perspective? How do you start defining the roles? And if you're issuing equity to each one, what's sort of the best practice? How should we think about this?
Well, there are, so roles and responsibilities is obviously that's a decision that the founder has to make, right? So let's say that I come up with I come up with an idea in the legal space, right? And so I have the legal background, and I can so I know what the legal field needs, but I don't have any technical background. So I may need a software person to join me to build the MVP or build a prototype so that we can go out and start experimenting, right? So then if I come up with if it's my idea, then I have to look for someone who can help me from the technology perspective, right? Then the roles are pretty well defined. Hey, so I'm going to be the person that brings the industry input or the domain input, and there's another person who's going to build the technology, right? So the roles and responsibilities kind of depend on what skill sets each person has, right? What is it that your expectation? What does the founder expect from a co-founder? And not expectations in terms of skill sets, and also expectations in terms of time. How much time is the co-founder going to be able to give me, right? I start talking to a software in my idea. I start talking to a software developer, and that developer has a full-time job. And if I like the person, and then I have to, in my mind, I have to, I should, if he's working full time, he has a 40-hour job, and if he's only going to give me time in the evening or give me times on the weekend, then I am going into that relationship knowing fully well that those are his limitations, right? So, and then I have to set my expectations according to what the person is bringing to the table. But those are the discussions that you need to have as co-founders, right? What's your availability? How much time are you going to be able to give, and what are your skill sets, right? Do you think you can do it all by yourself, or you think you need to bring more people in? And no point rushing into those decisions. You don't need to rush into a decision and say, oh, yep, I found I found a co-founder. I know what his role is, my role is. You can all obviously you can spend time and see, talk to him. Maybe try and figure out, what is he going to bring to the table? What resources is he going to need, right? I mean, there's someone may come join the team and say, okay, fine, I'll help you with the development. That's what I do, but I need people, who can code, right?
Right.
So then I have to keep in mind that, hey, he's not going to be able to do the job all by himself. He also needs other people, and those are things that you figure out by talking to each other, and once you have a good understanding of what is your co-founder bringing to the table is when you start talking about, how should I compensate him.
Right.
Right.
And yeah, that's where the equity discussion comes in. And it's always better to have those discussions sooner rather than later, because as you sort of progress in the project, those conversations will become difficult.
Oh,
right?
absolutely. I mean, once you have decided on the person, and once you have defined the roles and responsibilities, and once you have defined your expectations, and once he has committed to certain in terms of time or availability, once he's made those commitments, then yes, you should be talking in terms of, how do you compensate him. And
Yep.
you could always say, hey, I'm going to pay him salary, but where's the capital going to come from, right? To pay him. So equity is fairly typical and fairly standard way of compensating your co-founder. And splitting the equity, like I said, it depends on a few things. You could sometimes you end up finding a co-founder who could say, yeah, you know what, I'm not expecting any money. I have a job, or I've saved up, or I had a successful exit already under my belt, so I'm going to be able to commit some capital as well. So you can have, this shows more skin in the game.
Yep.
Right? If you have a co-founder who likes your idea and is willing to commit his time and is also willing to bring capital to the table, that means he's willing to put more skin in the game.
Right.
And that should also be part of the discussion, right?
Yep.
But these are things that you like I said, what is he going to bring to the table, and what is his role and responsibilities will determine how much equity you give.
How you compensate them.
How you compensate.
No, that's perfect. And I guess this leads us into another question, sort of terminology, that I'll get into in 1 second. But I just want to, I know we have a lot of people in the audience. So we're going to take Q&A at the end. So right now, as you're listening to Azad speak and you're thinking of questions, just click on the Q&A button on the bottom of the screen and type in the questions. We'll go through them at the end, and we'll make sure we answer all of the questions. But having said that, Azad, let's get back to the conversation. I want to define some of these terms because, as a new founder, this can be very confusing. And you already mentioned a couple of things. You talked about, common stock or restricted common stock. You've talked about stock options. What's the difference, and how do we sort of assign who gets what?
Yeah. So the who gets what depends on the timing, right? So think of it this way, that let's say you and I start working together on a startup, and we've been working together from day one. We incorporate the company. There is literally no value in the company, right? I mean, we're working with an idea, but the idea is
right.
What's the value in an
Start
idea?
at zero,
right? So on day one, we split the equity, whichever way we do, right? There is zero value in those shares, right? We in Delaware corporations, you always have a par value, and we end up using par value to actually give par value as the actual value of the shares to issue equity to the founders. Now think of it this way. Two of us, we split the equity, we issued ourselves common stock. Now we have to think about, hey, what happens if Azad tomorrow he loses interest in the venture, right? Or he finds a job somewhere else and he moves, and we've split we've split 60-40. So should Azad, if he was given 40% and he works with you for a few months and then he leaves, should he be able to walk away with the 40% of the company and you will continue to work on it? But he is not really contributing, but he has 40% of the company. So
Right.
that's where, that's where the concept of vesting comes in, right? Initially, that's so that's one of the restrictions on the common stock, is that the shares that are issued to the founders or the co-founders will vest over a period of time, and they are subject to the right of company's right of repurchase, so that if you leave, then the company can buy back the invested shares. That's one restriction on the shares, and that's the reason why common stock, when it's issued to the founders, it's called restricted common stock. It's the same common stock, but it's called restricted stock. Why? Because there are certain restrictions. You can sell those shares. There's a right of repurchase. There's a right of first refusal the company has. So there are those set of restrictions on those common stock, and hence it's called restricted common stock.
Got it.
Now, the question is, should you be giving restricted common stock or options? Well, there are tax consequences. So if, like I said, if we started a company together and from day one we split the equity, then there's no value. So it can be common stock. Now think of the scenario where you were the sole founder and you worked on your idea, and you've been able to bring it up to a level where there's some value in the company. I come along 6 months, a year later, and let's say the company's value for just for the sake of argument, we say, it's $100,000 is the value of the company. Right. Now, when you give me 40% on that date, then I'm getting $40,000 worth of shares, right? The company's value is $100,000. I'm getting $40,000 worth of shares. Now, the IRS is going to say, Azad, you got $100,000 worth of shares for your services as a co-founder, and hence we are going to tax you.
Ah, okay.
Right? So, because you got $40,000 worth of shares in your pocket, right?
Right.
Now, would I want to pay those pay those taxes? No one wants to.
Right.
We could have the best intentions. We could be the best team. We could do everything right, but where's the guarantee that we'll be successful?
Right.
Right. There's no guarantee that it will be successful. So, what happens? Let's say I got $40,000 worth of shares, and I say, you know what, I'm going to pay tax on it. I end up paying taxes on the company. A year or two later, the company doesn't get anywhere. The company gets dissolved, right? So what has happened? I paid taxes on shares, which didn't get me anything in return. Will the IRS refund me those taxes? No way.
No. Right.
So no one wants to pay taxes on the shares of a startup. Hence, the concept of options come in. Now, the option, as opposed to shares, where you give restricted stock and become a shareholder of a company, the option is the right to buy shares. It's an option to buy shares in the company. You can exercise the option, buy shares, and then become a shareholder. But until you do that, you're only an optionee. You're not a shareholder in the company. Now, if the option is issued at a fair market value, so for example, in my example, you tell me, Azad, you were getting 40% shares in the company, and your exercise price is $40,000. Meaning, whenever I exercise, whenever they vest and I exercise, I will have to write a check for $40,000 and then get the shares. Meaning, what I've done is I've essentially told the company that whatever is the value of the shares today is what I'm going to pay for these shares later on, as in when I want to exercise them.
Right.
So that's the reason why options are issuing options is tax-free. So there's no tax on when you issue an option, and the option is issued at fair market value. There's no tax on that.
Because nothing is really changing hands. You're really just signing a legal contract. That's it.
Absolutely. You basically put no value in my pocket on day one.
Got it. Okay.
Right. So that's the reason why it's so
very interesting.
To go back to your point, if the company has you and I start working together, we issued shares to each other right from day one. Another person joins us a year later, he could be getting options.
Right.
right? But there are certain, like I said, there are tax consequences when these shares or options are issued, but there are also tax consequences when, later on, if the company is successful.
When they're exercised, right?
When there's an exit, right? I mean,
Mm-hmm.
if you held those shares for 2 years, then you get long-term capital gains. If you
Yep.
exercise the option right before the company is getting acquired, then you haven't held them for 2 years, and you have different tax consequences.
Yep.
So
Absolutely.
those are things that we have to keep in mind.
Really interesting. Okay. One thing I do want to jump back to is the vesting schedule that you sort of touched on, and I just want to make sure we clarify that a little bit for the people in our audience. This is essentially, vesting schedule is essentially a way to tie the co-founder or whoever your sort of partner is to the company for a longer term.
Correct.
Right?
Yes.
And tell me how it normally works. I understand there's a cliff and there's several years. So walk me through that.
Yes. So depending on whether you're giving common stock or whether you're giving options, right? The vesting works differently. So let's talk about a common stock. So if the company is issuing common stock subject to vesting, then a typical vesting schedule is very standard vesting schedule is, and you may have come across this term, is 4 years, 1 year cliff. So basically what you're telling the person who's getting the shares is that, Azad, you're getting 40% of the company, but this 40% you will earn over the next 4 years.
Yep.
Okay. So one could say, okay, I'm earning 10% each year, right? But that cliff comes in, and essentially what you're telling me is, Azad, you have to at least work with me for 1 year so to vest your first 10%. So after you work with me for 12 months, your 10% will vest, and the remaining 30% will then vest over the remaining 36 months on a monthly basis. So then you don't need to have an annual cliff, meaning, if I worked with you for 12 months, I get my 10%. If I worked with you for 18 months, then I get my 10%, plus then I get also the vesting for the 6 months after the first year that I worked with you. So that's the vesting, and that is the same whether you're an option or you have stock. The vesting schedule works the same way. Now the difference where the difference is the fact that in an option, like I said, you're not issuing shares, you're issuing the right to buy shares. So as the option vests, I have the right to buy the shares that have vested.
Right.
In my first example, I was given 40% of the company on day one, and I was told the company has the right to buy back the unvested shares. That's the difference. In an option, I am basically being told, Azad, here's an option. You can buy up to 40%, but you have to stay with the company for 4 years to buy the entire 40%, right? If you leave earlier, then you can still buy whatever is vested.
Right.
But like I said, I have to go through these steps. One, something should have vested. Second, I should then have to buy them, exercise my option, write a check to the company.
Right.
So that's the difference between the two concepts.
Got it. Very interesting. I know there are a bunch of things that we wanted to cover, but one of the main thing was how to sort of document all of these things. We've talked about a lot of stuff, and I know attorneys always love documenting, and every contract is 25 pages long. What's your sort of how do you view that? The whole process of documenting all of this and making sure you get it in writing with signature and all of those things.
Yeah. Well, see, we have to keep ourselves busy.
That's right.
We have to watch out for our own interests, right? So if I'm drafting a document and I make it very simple, where anyone can read it and understand it, then why would they come back to me and pay my hourly rate, right? So I have to write a document, and I have to write a lengthy document, which first of all scares anyone who gets a document, gets scared. Am I really going to read this? And if I read it, am I really going to understand anything? No, you will not. Jokes apart. So yes, it's very important that you document everything. And when I say everything, I really literally mean everything. Your discussions with your co-founder. How much equity are you giving? What is the vesting? How is this equity going to vest? what happens if there's a change, if I leave, right?
Mhm.
Intellectual property that your team is creating for you, that has to come to the company. You have to have documents. You when you're talking to, you could, you could promise me, hey, Azad, I think I'll give you 25-30%. Okay, now is it going to be 25% or 30%?
Right.
Right? I go home and write an email to you, hey Dhaval, you and I spoke and you said I'll give you up to 30%. See, it's
Right.
changed, right? And you never pay attention to that and say, yeah, you know what, I think that's fine. I don't mind. And then there's no discussion around, how will this 30% vest, or how will this 25% vest? What am I doing for the company? I work with you for a few months and then I walk away.
Right.
I could just use that email and say, hey, you said you were going to give me 30% of the company. Where are my shares?
Right.
So, it's important that you, like I said, I'm going back to the point that I was making earlier, and I'm not saying that because, because I'm an attorney, but attorney, you need to have attorneys who understand this landscape well, who have been through these, situations where, you know, it, we are all human beings, right? Day one, everything is hunky dory. You just love your partner. You have no problem with it. You think you're going to create the next unicorn, just the two of you. And six
Right.
months later, oh my God, I thought he's going to be giving me at least 10 hours a week. He's not even
Right.
answering my phone. I have to call him like 10 times before he picks my phone. Hey, he's not even responding to my emails. And this happens.
Right.
I go through this. Believe me when I say this. I go through these things on a pretty fairly regularly, right?
Right.
So things change. You thought you had the best partner, but the partner, he comes, he gets attracted by something else, right?
Right.
So he starts looking at something else, and so then you have to how what are you going to do if you're going to rely on your emails?
Yeah.
You're going to be in a dispute, and it's
Yeah.
not going to be a happy situation. So you need to document your equity issuances. Now you need to document your IP, right? Keep in mind, if I write a piece of code, if I'm writing a software, developing a software, I write a piece of code, the copyright in that code belongs to me, even if you're paying me for that. Now I have
Right.
to assign it to you or to the company to make sure that the copyright belongs to the company, that the code belongs to the company.
Right.
If you haven't documented that, you paid me, thousands of dollars to write a piece of code, but you never documented that IP belongs to the company. I may go back. Good luck when you talk to your investors, and your investors tell you, "Hey, go get this developer to assign the IP," and then my antenna will go up. Hey, why has Dhaval, after 3 years, all of a sudden, why is he chasing me to
Right.
assign this code to him? Is he up to something? Or hey, he's
Right.
also sent this email saying 30% equity is going to give to me.
Right.
Is now the right time to talk to you? Were talking to
Yeah.
your investors, you're in diligence with your investors, and here's this one guy you worked with for a few months who now wants 30% to sign that piece of
Right. Right.
document that you put before him. And these are
And now, yeah, there is value in the business. There's value in the code.
value
So
in the
now
business.
he'll come knocking.
Absolutely. So these things come back to haunt you. That's the reason why you should always document your discussions. Investors will do their diligence. If
Yep.
you are talking to an investor and the investors know it's a sophisticated investor, they will hire a law firm. There are a few things that they always want to look at. One is the cap table. They want to
Yep.
have a clean cap table. Okay.
Yep.
Second is they want to have clean IP ownership. Of course, there
Mhm.
are other things that that also come. They want to make sure that the company has been that you've been following the formalities of a corporation, right? I mean, you've had your board's been meeting, and important decisions have been made by the board members, and that
Yep.
you properly documenting those things.
Right.
But cap table and IP, absolutely important,
Right.
very important.
And emails don't work. You need to have an
Emails
attorney.
don't
You
work.
have that contract.
Emails don't work. Your and like I said, there are certain things that you can clean up later on, and certain
Mhm.
things you just can't clean up later on. They are not in your hands. And cap table and IP are two things that are very difficult to clean up.
Right.
So yes, documenting everything and documenting it properly is absolutely necessary. And it
Fantastic.
brings value to the company, right?
Absolutely, absolutely. Yeah, and investors, or your potential acquirers, they're not going to want to see emails. They're going to want to see legal
No.
documents.
Yeah, I mean, if you're relying on emails, good luck talking to a sophisticated investor.
Right, exactly, exactly. So Azad, thank you so much. This was fantastic. We have lots and lots of questions that have come in. So let's go through them real quick. If you, here's one question. Let me see. We answered that question. If you're putting a simple LLC inside a trust and transferring the LLC along with other assets to the beneficiary, um, when you die or become incapacitated, how does it work? I know this is getting into more detail than we probably were hoping for an introductory session, but what's
That's
your view on sort of
yeah,
the Russian dolls of entities?
yeah, no, that's a question for your estate attorney, your trust attorney.
Okay.
That's not my area of expertise, so I don't want to say something which is clear, which I don't feel comfortable saying. So
Got it. Got it.
that's a
Okay.
question for the attorney that helped you form the trust, and he or she should be able to answer that very easily.
Got it. In general, I'll sort of expand on that question a little bit, but in general, if you have, if you're nesting entities, so if you have, let's say, a C corp, and then have a couple of LLCs underneath it, what do you think of that structure, or do you prefer just separating the entities to the extent?
So the question is, why are you doing that?
Right.
What is it that you're trying to achieve? Why do you have a C corp on the top and then LLCs as the subsidiaries? If I, is that your question?
Yeah, exactly.
But why would you do that? What is it? See, again, if you have a business reason for doing something, right?
Right.
See, the structure that you have, it's dictated by your business reasons, and then it's dictated by your tax planning, right?
Mm-hmm.
So if your business demands that you have this kind of a structure and your tax lawyer blesses it, then absolutely no problem, right? But you have to think about, why am I doing this? What am I trying to achieve?
Got it. Got it. Okay. This next question might be more targeted towards accounting issues, but let me get your perspective from a legal perspective. If you have an LLC, and let's say you're putting, you're depositing checks into that LLC bank account, and then
Mhm.
you're sometimes moving funds to your personal account or vice versa, which is technically co-mixing funds. Are there any legal consequences that can come from it? Obviously, there are a lot of accounting
Yes,
implications too, which we
absolutely.
won't touch on.
No, like I said, one of the, I think in the right in the beginning, what I said was that, why do you form companies? Why do you incorporate or form a LLC? Is that it brings you limitation of liability, right? It protects your personal assets from the business, the risks of that business, right? Now, one of the things that you have to keep in mind is that, in lieu of getting that protection, what are you doing? You're forming an entity, and then the law says that if you form an entity and you want that protection, we will give it to you, but make sure that you're complying with the formalities of that entity, right?
Right.
We talked about the formalities, like LLCs are more flexible, corporations are less flexible. But LLC and corporations, when it comes to commingling of funds, it's the same thing. You're commingling funds. You're not running the business. You're not following the formalities of the business. Tomorrow you get sued, right? Individually get sued. Then I'm sorry. If your company gets sued, then that person can come after you for against your personal assets, because you'll say, but you were
What's the
doing business.
difference?
There's no
Right.
difference,
Right.
Yeah. So you were the alter ego of the company, and so you blow that protection that you have. We call it the piercing of the corporate veil. That the courts will look into it and say, yeah, you know what, this guy was really. I mean, there's no difference between him and his entity. He's
Got
been
it.
commingling assets, he's been commingling funds, and they will pierce the corporate wheel, and you will hold you liable, and your personal assets are then on the line too.
Got it. So short answer, don't do it.
No, definitely.
Okay, perfect. Let's answer another question here. If you're raising a friends and family round, what's a good offer to investors? Should it be convertible notes? And we're going to get into this a lot more detailed next time. But should you offer shares? How does this complicate the cap table, et cetera, et cetera?
Yeah, so again, that's a question that comes up fairly regularly, right? So if your friends and family are accredited investors, now there's a difference between accredited investors and non-accredited investors. If you are accredited investors, then from a securities law perspective, you have less disclosure obligations,
Mm-hmm.
right? And 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 so you're protected, right? If you're talking to accredited investors, all angel investors, the VCs, they're all accredited. So you're not required to do lengthy disclosures. There's an assumption, or there's a presumption that they know what they're doing, that they will do the diligence, that they know that they can take the risks, right?
Right.
So if you have accredited investors, then you have a lot more flexibility, right? I mean, you can then think in terms of giving them convertible notes or safes and all these. If you look at the safe, one of the things in a standard safe, one of the representation that the investor makes is that I am an accredited investor.
Right.
So if your friends and family is accredited, then you have a lot more flexibility. Keep in mind, these convertible notes and safe will convert into preferred stock one day, right?
Mm-hmm.
The same stock that you will end up issuing to your investors.
Right.
So if your friends and family are not accredited, then you have to think about, should I just give them common stock that I'm giving to the founding team? Because I don't want to have a situation where when these convert, I have new investors that all accredited, and then I have these friends and family
My
investors,
grandma, right?
yeah, who's non accredited, and then that creates a complication. Then you have to think about it. Should I give a note, or should I just do a common stock?
Fantastic, fantastic. Yeah. By the way, just so you know, that the comments are sort of going through the roof. We still have tons of people on the line, and a lot of sort of excellent topic, excellent speaker. They've been giving you a lot of compliments. So I just wanted to pass that along.
Thank you. I'm glad it's been helpful.
Another question: if you have a C corp in Delaware, and all of your clients are out of California, everybody, all of your workforce is out of California, you just have one officer who's based out of California. Do you still have to pay the California franchise tax? What are sort of the restrictions there?
So you have a Delaware corp, and all your clients are in California?
Outside California.
Or outside of California?
Yep.
And you don't have any employees in California?
Yep, none in California.
And you have just one officer in California?
Yep.
Well, that's a tricky one. There's no bright line test. What California requires is that if you're doing repeat business in California, then you have to register in California. So, obviously, if you were to ask the California franchise tax board, they will say, oh, absolutely, you have to register.
Right.
You have an officer. The officer is going to be making decisions here in California. So you're doing business in California, right? If the officer is getting a salary, then he'll be paying state tax, and that's when they will say, okay, fine, he's based in California. This company is paying him taxes. This company registered, and they may or may not. There's no bright line test. What we think of is that if your officer is going to be making decisions and is going to be signing documents in California, then yes, it's always at the end of the day, the risk is you have to pay that $800 in California, or risk them doing an audit and then imposing penalties and whatnot.
Yeah, so and that can be a lot more painful.
Exactly, and you don't want to go through that process anyways. You're going to build a company. There are enough challenges. You don't want the franchise tax board coming after you.
Right. So whatever that small fee is, you're better off paying it and just not having that headache.
That's my view. Yes.
Okay. Perfect. So this is another question that is very applicable to even myself. So I'm glad someone asked this. But if you have an entity in California and you're looking to move it to Delaware or someplace else, Nevada, for example, they don't have any franchise tax. So how does that work? Do you have to essentially shut down your California entity and then move? or
No.
can you transfer? How does that work?
Yeah, so it depends on the law of the state in which your entity is, and it also depends on the law of the state in which you want to incorporate, or in which you want to move. Now,
Move to.
Delaware, like I said, Delaware is very flexible. Okay, so Delaware is good. So if you are a California LLC, then the California LLC Act allows you to just convert. So
Okay.
you draft a plan of conversion, you have your members approve the plan of conversion, then you prepare a certificate of conversion. It's one-page document. You file it in Delaware, then you prepare a certificate of conversion. There's a California form. You file it in California, and then just then just convert. It's very simple. But if you are a corporation, the corporation is not, there's no conversion of a corporation in California. So then what you have to do is then you have to do a reincorporation. Merger is one way of doing it. So what you basically do is you form a Delaware corporation, and then you merge your California corporation into the Delaware corporation. The California corporation goes away, and then you become a Delaware corporation.
Got it. Really funny comment that just came in. Just rent a U-Haul and you're all set. I thought that was made me chuckle a little bit. Great. Here's another question. If you and you have a co-founder, and if two of you decide to share equity 50%, 50%, are there any legal implications? When you're making major decisions, when there are, there's turmoil. Not having that 51-49, having that equal share, 50-50, does that cause any heartache?
Absolutely. I mean, you basically and I'm assuming that when you're a 50-50 owner, then you will have two board of directors, and both the founders will be on the board. So you have a perfect stalemate situation, right? Where you have two founders on the board with 50-50 each. With two votes on the board. I'm sorry. At the board level, you don't have equity.
Right.
Each board member gets only one vote. So whether I have 50% or 10%, when I'm on the board, then I have one vote. So that's a situation where you have two people owning equal ownership of the company as shareholders, and then both of them being on the board. What happens if there's a stalemate? If you think through that and you say, well, what, if there's a stalemate, then this is how we'll resolve it.
Right.
Then yes, you can nothing wrong with that, but you just have to keep that in mind. Sometimes what we say is that if you have that situation, hey, bring on an independent director, right? Mm-hmm. Someone who can be on the board to break the deadlock.
Right.
Right. Independent director who's neither related to
right.
neither of the co-founders, and that's fine. And sometimes you see that if there's a stalemate, it becomes a deadlock, and the companies just don't get anywhere. We've seen those situations as well.
And companies generally end up failing at that stage.
Exactly.
So you're better off having an odd number of board members always. So even if you have 50
board members
partners,
should always be odd. Yes, the board should always be odd, so that you don't have you don't have a situation where the board is deadlocked.
Right. Perfect. So this is actually a follow-up to our previous question where, if you have a California entity, let's say it's a California LLC, you're trying to convert into a Delaware C Corp. How long does that process take? What's the conversion like?
Like I said, if you have not complicated the cap table of the California LLC, if the California LLC cap table is straightforward, there are a few members and they have, same types of units or membership interests, it's fairly straightforward. It's not a biggie. You set up a plan of conversion, have the members approve the plan of conversion, file two certificates, and you're done. It's not expensive. It's of course you will have filing fees in Delaware, and you'll have filing fees in California, and you'll have a little bit of legal cost, but it's not much. It's not prohibitively expensive. But if you have complicated the cap table of your LLC, and this comes back to my earlier question earlier point that I was trying to make, that if you are starting a tech startup, then you have to think about pros and cons. Should I even bother setting up an LLC, or should I just become a corporation? Should I be in California or Delaware? And why not Delaware corporation if I know I'm going to be out there trying to raise capital, sooner than later? So if you complicate your cap table and you have membership interests and you have profits interest units and whatnot, then yes, then like I said, because LLC is a pass-through structure, you have to think about how this conversion is going to affect the members, and different members may have different tax implications depending on what type of units they have.
Got it. So more cooks in the kitchen, the difficult it is.
Absolutely. Yeah.
Got it. Okay, so here's the next question. Lots of startups are trying to use offshore entities to get work done. If you are a US entity trying to function in that environment, or if you're an investor trying to invest, how do you protect yourself? How do you work in that environment?
Well, if you are an investor, then it's a completely different analysis, right? I mean, then you have to look at the securities law of that country, what the regulatory regime is, how much can you invest and what kind of shares can you get. Different countries have different ways of handling that. So as an investor, it's a totally different analysis, and that's something that you have to think about. If you are a US company and you're hiring an overseas company to help you with developing the product, developing IP, whatnot, coding, then you just need to make sure, like I said, you have a proper agreement, a services agreement between your entity and the foreign entity, and the services agreement should clearly say that whatever they do will belong to your company. And
right.
Then at least you have done everything from your side. Now if you want to be extra careful, then if they are developing code, then maybe file a copyright application, right? Have a copyright stamp on it that yes, copyright on this code belongs to the company. But or file a patent. If it's a patentable, if they come up with a patentable invention, then make sure that they have assigned, not only you have the services agreement which says everything belongs to the company, but make sure that they have assigned that particular patent as well.
Patent to you,
so that so that they can come back later on and say claim ownership on the patent.
Fantastic.
Yeah.
This goes back to document, right? Have clear legal contracts, especially if you're working with folks offshore.
Absolutely, yes.
Perfect. Here's another question. When should we consider a buy-sell agreement?
I'm assuming that's between the co-founders.
Between co-founders, yes.
Yeah, you could right at the time when you're dividing the equity, especially when you're splitting it 50-50, then even more so, right?
Right.
But keep in mind that these buy-sell agreements that the founders enter into, when you are talking to investors, these buy-sell agreements get terminated. Then you have the investor documents, and all founders, everyone who has shares in the company, they all sign up to the investor docs, and the investor docs are set up. They take care of everything. Everything that your buy-sell agreement will be taken care of in the investor docs. Now, so your buy-sell agreement, is sort of like a stopgap between when you form the company and when you have investors come in. Right. Okay. So yeah, it's you can do that right away.
Got it. Okay. Here's another question. This one is a little interesting. It made me chuckle, but if you start with an entity in, let's say, California, let's say it's an LLC, you're starting to take in, investors, and you transfer or you form a new Delaware entity. Let's say it's a corp, it's a C corp or an S corp. Then how do you work with the IP? Should you transfer the IP? Should you keep them as two separate things? I'm guessing investors probably want it in the Delaware entity. So,
yeah. So
So
like I said, if you have a LLC and you convert the LLC into corporation, then everything automatically goes into the corporation. You don't need to do anything. You don't need to do any separate assignment. It's basically, you sort of think of it this way, that you've taken off your coat and you're wearing a different coat, but everything else remains in the entity. Of course, your members now own shares in the relevant corporation, but otherwise the business remains as is. You don't need to do anything from a business perspective. So you don't need to assign IP from the California corporation LLC to a Delaware corporation. That's taken care of by the conversion itself.
Got it. Okay.
Yeah.
Now, here's a question about intellectual property. This is interesting. If you have a novel business idea, can you patent a business model? And this is interesting because people are patenting mobile apps and certain ways of you know getting things done. What's your view on that?
See, I'm not a patent attorney, so again, this is one of those things that's a question that's for patent attorneys, that they're best. My understanding, again, my very basic understanding is that business concepts are not patentable.
Right.
Business methods are not patentable. They used to be, but they're not. So it's becoming more and more difficult to first of all get a patent on a business idea, and then even if you get one, then to enforce it. But that's again, when you talk to your patent attorney, he may, based on your idea, he may be able to, when you talk to him, he may be able to come up with something that's that's patentable. It's your software that's at the end of the day, it's, if it's a software that's going to implement your idea, then you could say, hey, there's a technology that I'm trying to patent, and not the idea. So talk to your patent attorney. They can come up with strategies and guide you better.
And there might be certain details that you can patent.
Absolutely. Absolutely.
So
yeah.
There are lots of ways to sort of get around that. So there's a question about crowdfunding, and to that person who asked that question, I'd suggest stay tuned for our next event. Next event is all about funding. So we'll certainly address your question there, and we'll talk more about sort of strategies and what things you need to sort of get done. Let me get to the next question here. So how do you specify transfer of a simple LLC to a beneficiary? So this is essentially, transferring your interest in an LLC to someone else. How would that work?
I mean, I don't understand. That seems like a trick question.
No, I think.
But I don't understand what is a simple LLC, and what do you mean by a beneficiary? So let's say that if it's a single member LLC, let's say if there's a single member LLC, I have my business and I form my LLC, and I am the only person that has any interest in the LLC, right? Now, if I want to transfer it to someone else, then I will just assign my membership interest to whoever wants to buy it.
Yeah,
right?
No, so I think the question more is, if there was sort of death or some other unforeseen event, then can you just leave your beneficial interest in an LLC through a will to the next person?
I think so. I mean, it's your membership interest in an LLC are assets in your hands, right? So you can give it the way you want.
Got it. Okay, so it would work as just like your cash or bank account or anything else.
Yeah, I mean, if if there's liability in the LLC, the beneficiary may not be a beneficiary of anything.
Right. Okay, so here's the next one. This is again interesting. If you are moving across state lines, again, California to Delaware, Delaware to California, et cetera, the question is sort of a trick question in my opinion, but how easy is it? Is it rocket science, or can anyone, not anyone, but can you just hire an attorney and just get it done in
conversion?
Yeah.
From a California LLC to a Delaware corporation?
Mm-hmm.
Oh yeah, it's very easy. I mean, it's not rocket science. It's fairly simple. Like I said, it depends. The two things that your attorney has to look at is, which jurisdiction is your entity in, and which jurisdiction do you want to convert into. So if both the jurisdictions allow conversion, then that's even better. Filing 2 certificates of conversion and doing it. It's fairly straightforward. You don't need to take the form and travel to Delaware.
No U-Haul necessary.
Yeah.
Absolutely. Okay. A couple of other questions about VCs and angel investors, and in interest of time, I'm just gonna say, come back to us next time. By the way, our next event is on March 11th, and we'll have Azad back on, and we'll
18th or 11th?
Oh, sorry, March 18th. Thank you for correcting me. March 18th, and we'll have Azad back on, and that session will be all about funding and crowdfunding and VCs and angel investors and all that kind of good stuff. So we'll be talking about that. Let's see, a couple more questions here. I'm just trying to pick out the best ones because I think we only have 5 more minutes with Azad here. So here's a question. This is interesting. If you have, let's say, $1 million loan that's outstanding, and when you, okay, so this is a little bit tricky. You have an LLC, you have $1 million loan that's outstanding, you convert to C Corp. Does it become a liability for the C Corp? And if the C Corp starts to generate cash flow, can you pay the loan off with the cash flow? So
yeah, like I said, your business remains the same. You just, you work LLC, now you're a corporation. So obviously, formalities change, tax implications are different, but the business remains the same. If you had an outstanding loan in the LLC, when you convert into a corporation, the loan remains a loan, right? It now becomes a loan on the books of the corporation. And then if the company starts generating cash, then you just like paying any other loan. Obviously, the company can pay it off.
Got it. Perfect. And here's a last question. This is about compensation structures, and we talked a little bit about assigning equity. Can you touch on what other kind of compensation structures we can use? It could be in form of cash versus equity. It could be many other things. What's your view on that?
Yeah. So I mean, if you can afford to pay cash, then absolutely. I mean, it really depends on how you can compensate. Whether you have capital to compensate someone with cash, and what is the other person's expectation, right? So now keep in mind one thing, that if you are hiring, we've heard about this whole employee contract, independent contractor versus employee, and how in California it's become difficult to now classify your service providers as contractors. So the law is that that they are more likely to be treated as employees than as contractors. The formalities, it's becoming more and more difficult to classify them as independent contractors. Then so if you have employees, if someone you thought was a contractor, but now is all of a sudden you find out, oh no, he's more of an employee than a contractor, then you have to at least pay minimum wage, right? And keep in mind that whatever equity you may give him, you have to pay the minimum wage, right? That's the law. So if you hire someone and promise him 10% equity, and this happens not, I wouldn't say that it happens all the time, but there are some bad apples who would basically they will get some equity in the company, they will put some time in the company, they maybe have not vested anything, and then they leave. They leave after 9 months, and then they realize that, oh my God, you know what, I had this option, or I had this stock which was going to vest on a 1-year cliff, and I left before the first year. I didn't really get anything out of the company. So 9 months I just gave for nothing, right? They go to a plaintiff's lawyer, and who does employee side plaintiff, employee side litigation. First thing the lawyer is going to do is very standard letter, basically saying, hey, you hired my client, you misclassified him. He was an employee. You misclassified him as a contractor. You didn't pay him his salary. You didn't pay him his overtime. You didn't comply with employment laws, and you didn't do this, didn't do that. And by the way, we are going to let the EDD know. Right. And then you have a huge issue on your hands, right? And then you sit down and you negotiate a settlement. Like I said, it doesn't happen all the time, but it happens. And then you sometimes you end up paying cash, because you don't to that person you don't want to give stock, right? Right. Because you want to get rid of that person. You want to end the relationship. Exactly. So sometimes you end up paying cash like that, but yes, to your question, that if you can afford to pay cash, then please then do that.
Do that,
And
right.
at least pay the minimum wage, so that even if the person says that, oh, I was misclassified, you know,
Yep.
there won't be any penalties there, because you've already paid him more than the minimum wage, right? Or at least the minimum wage. So he can't come back and claim that he wasn't paid anything.
Right. Azad, thank you so much. This has been a fantastic session. I really appreciate all of your insights, and I've seen a bunch of nice comments and great jobs in the comments and in the Q&A. So I know the crowd definitely appreciated you and appreciated everything that you had to share. Again, like I said, you'll be back with us on March 18th. So we'll continue the discussion there. That discussion will be focused on funding. We'll touch on angel investing, VCs, crowdfunding, all of the issues that sort of come up in that. There were a bunch of questions about that today. So I know that is a topic that people are very much interested in.
Yeah, sure.
And for everyone else who's still with us, make sure if you do want to work with Azad, if you want to get in touch with him, obviously you can get in touch with him through straddling, or you can just send me an email and I'll be happy to make the introduction. Also, if you want to follow us on Eventbrite, just make sure you follow us. We have a lot of events coming up in February and March, and all of those are sort of targeted towards giving startup founders all of the resources they need to sort of succeed in their business. So make sure you follow us, make sure you come back and attend more events, because our goal is to support you. Thank you again for attending the session. I really appreciate everyone.
One comment, one comment, I think what you should do is you should get the names of the attendees. So these lovely comments and amazing comments that we've been getting, at least we should know where they're coming from.
Absolutely. I think we had lots of people at one point, so I'll have to sort of go through that list and make sure we get them. But yeah, these people had really nice things to say about you. So yeah, absolutely.
All right.
Any final thoughts, Azad?
That's it. Yeah, just make sure you working with a good attorney.
Good advice. All right, guys. Thank you so much. With that, we will close our session for today, and we hope to see you in the next one. Thanks. Bye.
Thanks so much.